Good evening, everyone. Welcome to today's seminar. I'm Raymond Yang, council member of HKIArb, and also of council of international law firm, Bosch-Broeren, in Hong Kong. Today is our great honor to have three ladies from Omni Bridgeway to give us a talk. A very hot topic of managing the cost of dispute. I think most of us should know the cost of international arbitration have been quite concerned to the business and also to the lawyers, because previously we believe international arbitration was advantage is cost effective, and also because of confidentiality and enforceability source of advantage, all of us know and appreciate the international arbitration. But for the past or the recent years, the costs have been especially a concern for the business, because for cross-border arbitration and especially for investment arbitration, which I think the ladies will shed light on us to give us some idea and example of the internet investment arbitration. So it could be millions of dollars to run an investment arbitration for maybe run over a period, a couple of years, even more than 10 years. So today is lucky for us. So we have another option. We don't need to spend money out of our own pocket. We have third-party funder to assist us and help us with those kind of to manage and run the case with in a more cost-effective way. So that's today's topic. So without further ado, I shall hand over to the three ladies to give us the talk.
Thank you very much, Raymond, and our thanks to the HKIArb for having us tonight. It's a pleasure to be able to join everyone who's with us and to help discuss a little bit more about how to manage the costs of disputes these days, which, as Raymond mentioned, are increasingly expensive. We'll start with some introductions. So my name is Ruth Stackpool, and I'm an investment manager with Omni Bridgeway based in the Singapore office. Like Marjolein and Cheng-Yee, I work closely with the Asian team and also our offices internationally to originate and assess and manage funded cases. Before joining the funding industry, I was a cross-border dispute specialist in arbitration, qualified both in the UK and Australia, and my time in private practice saw me working with disputes teams at Debevoise and Plimpton in London, Oric, Harrington and Sutcliffe in Paris, and also Coudet Brothers before that in Paris and Sydney. Some of you may also remember I was based in Hong Kong for a number of years. I was managing counsel with the HKIAC and acting Secretary General for a brief period, and very much enjoyed my time living in Hong Kong. And that's also where I started my career in funding, opening what I think at the time was one of the first dedicated presences for a global merits funder in Asia. And then subsequently moved down to Singapore in 2019 at the time that I joined Omni. So that's me in a nutshell. I'll let Marjolein and Cheng-Yee introduce themselves briefly, and then we'll come back to the agenda and topics for today.
Thank you very much, Ruth, and hi everyone. Thank you very much for joining. My name is Marjolein van den Bos. I am responsible for the assessment and management of cross-border litigation here in Asia, but more specifically, I'm head of enforcement for Asia, and I will speak later on that during our session today. I am admitted to the bar in Amsterdam, and I'm also New York qualified. I worked in the private practice until 2013 as a litigation lawyer, and then I moved to the Philippines, where I worked as in-house counsel for a couple of years with a large Philippine conglomerate. And I moved to Singapore in 2017 to join Omni Bridgeway, and I've been working there with, well, really much enjoying it with the funder. And well, I'm looking forward to this session today. Thank you.
Sorry about that. I need to actually unmute to be able to go off screen to be able to unmute. Sorry, let me just go back to sharing the screen. Hi, everybody. My name is Cheng-Yee, Cheng-Yee. For the arbitration practitioners that are present on this call, you might know my name, or at least my initials, CYK, which may have figured on quite a few ICC arbitrations that you were in charge of, or arbitrators that, you know, or on my cases. I basically headed up the ICC, International Court of Arbitration Secretariat, for about 8 years in Hong Kong. So we managed all the Asia cases and EMEA cases for quite some time. And before that, I was practicing in international arbitration exclusively at Freshfields and also at Schupplin & Bock in KL. And I've been with OmniBridgeway since January 2018. I'm heading the Hong Kong office, and I'm absolutely delighted to be here. I'm so sorry I can't be there in person, but you know, with Omicron at the moment, it's probably best to do it over Zoom. Anyway, thank you very much for spending time with us today. I hope you find the talk useful. Thanks.
So we wanted to move through 4 main topics this evening, and we'll try not to take too much time because we would like to have some questions at the end. So if things come to you while we're going through, please do just write down anything that comes to mind that you'd like to ask us about in the Q&A box. And then to the extent that we can, we'll address those at the end. And if we don't get to them and you'd like to follow up with us separately, or you can leave your email address, we can follow up with you afterwards because we only have an hour tonight. So effectively, what we wanted to do was cover briefly at first, just an introduction to who OmniBridgeway is. I think knowing a bit of context about who we are and how we operate gives a bit more context to what we do. So having done that, then we'll look specifically at you know, the legislative context and the operating context in Hong Kong, and being closest to the day-to-day of funding in Hong Kong. Cheng-Yee will do that. She, as she mentioned, heads up our office in Hong Kong. So she will lead through that section, giving context to what's permissible and what's not, and what clients are asking us in terms of the products they would like to use. Then we'll look at how the funding relationship works. So move on to some of the practicalities in terms of, you know, the role of funders and how we operate in the context of a dispute that we're funding. And then last but not least, Marjolein will share her great expertise on how we then turn, you know, successful awards into recoveries for our clients, and some of the background in terms of how we do that. So moving straight into an introduction to Omni. Effectively, OmniBridgeway was a strategic combination of a number of different businesses. It has existed in one form or another for more than 35 years. And effectively, it was a combination of IMF Bentham, which was an Australian listed company, which started off very much in the merits funding side of things, and OmniBridgeway, the legacy entity, that was a specialist cross-border enforcement and recovery company, founded in the Netherlands and with a very strong footprint in EMEA. So coming together, we formed what is the largest global funding team now, and we have more than 180 professionals located around the world. I think importantly for those involved in disputes at this time, which are often multi-jurisdictional, you know, we have experts that match the nature of those disputes, common law and civil law expertise. And I think also importantly to know that we bring through our network not only professionals with backgrounds similar to my own, Marjolein's and Cheng-Yee's that we've just described, but we also have a number of specialists in-house within our team, including economists, financial experts, other recovery and business intelligence experts who really can help us to take a complete and very well-rounded view of a case that we're looking at investing in. So all of those things go into what makes up OmniBridgeway. In terms of then why you might choose to work with OmniBridgeway and some of the particular differentiators that might be of interest to you, I think without doubt, our strongest differentiator is our success rate. Well, I hope you agree that 84% success rate achieved over the course of more than 1,000 investments with more than 2 billion Australian dollars cumulatively at work is rather impressive. I certainly think it is. I think it's also important because it's an objective indicator of what we're able to do. We can identify strong claims and then help to achieve resolution for our clients. As a listed entity, this is something that we share, and that's not the same for all funders. And it also means that the veracity of our figures and the availability of our funding is quite transparent, which I think is important for clients who are looking for a partner, because essentially that's what a funder is in pursuing their dispute. So then moving on to the next slide, another particular differentiator that we have is our global expertise. So as you can see from the map, this relates not only to where we are on the ground, and you can see that in the small blue dots, that is where all of our offices are located. So we're on the ground with our clients and our advisors in many situations, but also because of the experience that we've had in terms of assessing or funding claims. And as you can see, that's represented in countries that are shaded in gold or light blue. Our expertise really does cover the globe, and it's quite unmatched in terms of that breadth of experience that we can bring to what we do. And so when you match those things in terms of where we are located and also our experience, we bring relevant languages, cultures, political understanding of local jurisdictions, and particularly regulatory environments to the case that we're looking at and to the client that we're partnering with. So I think this is very important in considering what we can do and how we do it. And then last but not least, the last sort of important factor I think that helps us to clearly stand out from those in our field is our expertise in the arbitration field. Hopefully you got that sense just from our introductions this morning. I mean, most of you already know Cheng-Yee. I hope I'm not unfamiliar to a number of you, and Marjolein, because of the nature of her work, tends to like to stay in the background a little bit to do her secret squirrel work. But we have over 30 professionals in our arbitration team. I don't think any other funder can really have that level of expertise, specifically in relation to the arbitration context. In Asia in particular, we're the largest on the ground team. We've got the office in Hong Kong and Singapore. And we are one of the few organizations with permanent staff deployed here in this region. And I think that's a very strong differentiator. On the side there, you can see two of the most respected independent directories recognizes our experience and our expertise very highly. So the extent that there's any necessity to corroborate what I've been telling you, then that's at least an independent source to verify that. So with that introduction to who we are, I think it would be good to then set a little bit more context by looking at what the situation is in Hong Kong in terms of what the legislation allows in terms of funding and also the types of products that we're offering there.
Thanks a lot, Ruth. Now, we seem to have a mixed bag of attendees today. So it seems to be ranging from arbitrators to legal practitioners, in-house counsel, corporate counsel, to even students. So let me just quickly start with a very basic description of what third-party funding or dispute finance, as it's also called, is. So third-party funding or dispute finance happens when an entity that has no interest in the legal proceedings finances the legal and other costs of those proceedings in exchange for a return if and when the arbitral award or the court judgment is favorable to the funded party, and the funder is able to collect on the sum that has been awarded to the funded party and payable by the losing party. Now, the difference between third-party funding and a loan, which is repayable, is that if the funded party loses the case or wins the case but is unable to recover any money from the losing party, then the funder usually receives nothing, not even a reimbursement of the costs that it invested during proceedings. So as you can imagine, it can take a number of years for the funder to A, fund costs during the arbitration proceedings, and B, potentially fund costs during the enforcement proceedings with no incoming funds until the end. It goes without saying that this is a business that carries significant risk given the uncertainties of litigation. And if you are considering third-party funding for your dispute, we would perhaps recommend that you're careful to choose very experienced and well-financed funders who have the relevant expertise and knowledge and with whom you're comfortable working with to try and ensure, as far as possible, a successful outcome. Now, let's go quickly into having a quick look at third-party funding for arbitration in Hong Kong. As most of you are aware, it's relatively new in this part of the world. Third-party funding for domestic and international arbitration has been permitted only since 2019. And up until 2017, the state of the law was not entirely clear as to whether funding was permitted or not for arbitration. It is clearly prohibited for most forms of litigation in Hong Kong by the doctrine of champerty and maintenance, which is an ancient common law doctrine that is now pretty much obsolete in many common law jurisdictions, but persists here in Hong Kong as a tort and a criminal offense. So there was a clear need to clarify the law, particularly in the context of arbitration. And there was also a need to allow claimants in arbitration to have access to justice for meritorious claims when, for whatever reason, they are unable to fund the claims by themselves. As many of you will know, it is not only impecunious parties who seek funding, but it has also emerged as an extremely effective way for any party to manage the financial risk of arbitrating and keep the costs off its balance sheet. Perhaps the most important consideration from Hong Kong's perspective as one of the leading arbitration hubs in the world. And it was also increasingly felt by the arbitration community here that we could not compete as a seat without offering third-party funding in the same way as other major centers like London, Paris, Geneva, and also Singapore. So those were the 4 key reasons why the Law Reform Commission started to consult on whether or not to introduce funding for arbitration and mediation in Hong Kong. And the result was a bill that was passed in 2017 and which took effect as a new part of the arbitration ordinance on the 1st of February 2019. And what Part 10A of the arbitration ordinance provides is that funding is permitted for arbitration and proceedings related to arbitration. So that includes emergency arbitrations, court proceedings related to the funded arbitration, and mediation also relating to the funded arbitration. It may eventually extend to standalone mediation, although that part's still, sort of put on hold. Now, funding can be provided in Hong Kong by a broad range of parties. Unlike in Singapore, where the funders need to be professional funders, in Hong Kong, there is no limit on who can provide funding, provided they fulfill the criteria that is mentioned in the ordinance. The key exception to this is lawyers. So under section 98(0) of the arbitration ordinance, lawyers, regardless of whether they're qualified to practice in Hong Kong or qualified to practice elsewhere, can't fund cases in which they are acting for clients. And it is mandatory for a funded party in a Hong Kong arbitration to disclose that it is funded and the name of that funder, but not mandatory to disclose the terms of the funding agreement. And then alongside the arbitration, there's also a code of practice, which came into effect at the same time in February 2019. And this sets out a broad set of standards that funders are expected to comply with. One of the key components is a minimum capital adequacy of at least 20 million Hong Kong to ensure that the funder is able to meet its funding obligations under the funding agreements. There is a prohibition around the funder controlling the conduct of proceedings. As you might be aware, one of the key concerns around funding generally is that the funded party may lose control of its case and that it may be dictated to by the funder. So that funders have adequate procedures. So this means that funders need to have adequate procedures in place to manage conflicts of interest and also any complaints. And the extent of their liability must also be clearly set out in the funding agreement. And that includes whether or not the funder agrees to be liable for any adverse costs order that may be made against the funded party. And the funder also obliged to remind the funded party that it should seek legal advice before entering into the funding agreement. One thing to bear in mind is that the code of practice applies to all funded cases where the seat of arbitration is in Hong Kong or where the lawyers acting for the funded party are in Hong Kong, although the seat of the arbitration might be elsewhere. And a very recent and related update that I'd like to mention is the Hong Kong Law Reform Commission's report on outcome-related fee structures for arbitration, or ORFSs, which was issued in December last year. The Commission recommended that the prohibitions on the uses of ORFSs by lawyers in arbitration taking place in Hong Kong and outside Hong Kong be lifted. And this includes all three types of fee structures: conditional fee agreements or CFAs, damages-based agreements, DBAs, and hybrid damages-based agreements or hybrid DBAs. And the report recommended that a detailed regulatory framework should be set out in subsidiary legislation, and that further client care provisions, if needed, could also be set out in the professional codes of conduct. And the Commission also recommended disclosure of the existence of any ORFSs, but not their precise terms. And just lastly on this slide, the HKIAC introduced some new provisions with its administered arbitration rules in 2018 to recognize and facilitate the new regime of third-party funding. And the rules now require disclosure of the fact of funding and the identity of funder. And there is an exception to the rule on confidentiality, so that it is possible to share confidential information about the arbitration with funders for the purpose of seeking funding. Whoops, right, quickly now on to sophisticated solutions. Now on this slide, I'm referring more specifically to what OmniBridgeway can offer by way of bespoke solutions to our clients. The first row that you can see is dispute finance. We provide that, or third-party funding, for all sorts of cases: single cases, portfolios containing multiple cases, group actions, defense funding, as opposed to funding claims. So single cases, not only can we provide finance to cover up to 100% of the costs of a single litigation arbitration or portfolio, we can also provide upfront working capital advances that our clients can use for other purposes, such as their normal businesses or living costs for individuals, loan repayments, and so on. And the beauty of a working capital advance that is provided on a non-recourse basis, and it forms part of the funded costs. So there's no corresponding liability on the balance sheet, and CFOs normally find this quite interesting. We also provide in-house cover for adverse costs and security for costs, so that if our clients lose a case, we pay the costs ordered against our client. This is pretty unique to OmniBridgeway. Other funders will require clients to obtain external after the event or ATE insurance, which is quite expensive and also adds an additional layer of due diligence and complexity to the cases. If our clients are ordered to provide security for costs, we provide usually an undertaking in the form of a deed to the respondent to cover their costs. And because OmniBridgeway is an ASX listed company with transparent financials, we find that our undertakings are usually accepted by the respondent in the tribunals. And then the parties can just get on with the main dispute. We can also share costs with our clients so that the clients pay their lawyers, for example, but we fund the arbitrator and hearing costs. Cost sharing is a way for the client to obtain funding for smaller cases where the economics are quite tight. Portfolios. So again, we can fund up to 100% of these costs. We tailor portfolios to suit our clients' needs, but essentially there's two types of portfolios: fixed portfolios, where the cases in the portfolio are predetermined, and then the portfolio is closed once these cases are resolved, or open-ended portfolios where the option to add more cases, there is an option to add more cases, for example, as disputes arise. Portfolios can consist of claims, defenses, if there's sufficient value in the claims to finance defenses, enforcement cases, and because our risk is spread across multiple matters, we can offer better pricing. For example, in relation to shipping claims, or IP claims, or construction claims. Multi-party disputes, this relates to group or class actions, including for shareholder, tax, environmental, product, and investment advice disputes. And defense side funding, so we can provide funding for defenses where there are large counterclaims. We can also perhaps fund pure defenses, but they require a much more complex structure to define success and to clearly identify the commercial benefit that we would share with our clients. An example that this might be a tax dispute. Say our clients are sued by tax authorities, and if their defense is successful, then we might receive a fee from the pool of funds that they retain. Working capital, working capital, I've just touched on this. Enforcement, So Marjolein will go into this further, so I perhaps will skip this in the interest of time and go straight on to claims monetization. We can purchase judgments and awards if our clients wish to monetize them and have if the clients have no appetite to continue fighting the case to enforce their rights. However, this is usually done at a significant discount given the risks involved to us. And we would actually prefer to work with our clients. So not to buy the claim or the award out from them, to actually to work alongside the clients, fund the enforcement, and provide a capital advance perhaps to them if they need it on a non-recourse basis. Lastly, and very importantly, downside risk management. It's a key point that can often be overlooked. So our finance is provided on a non-recourse basis. As I mentioned earlier, if our clients lose, they pay nothing. If they win, but they can't get any returns, they also pay nothing, assuming that we provide full funding for the case, because we can cover adverse costs. And we will only get a reimbursement of the funded costs and our return on investment if A, our clients win, and B, we successfully recover on the award or the judgment against the respondents. We find that well-financed clients are increasingly open to third-party funding as they can get complete downside financial protection to pursue their claims in exchange for a slice of the upside if they can get recoveries. So let's have a quick look at the HKIAC's experience. So far, there hasn't been a huge flood of cases, which might reflect situation elsewhere in Asia as well as elsewhere in Hong Kong beyond HKIAC administered cases. The HKIAC is aware of 10 funded cases in its administered caseload. You can see on the slide that the funded parties are coming from all over the world, including North America, BVI, Cayman Islands, the UK, United Arab Emirates, Malaysia, Singapore, and also mainland China. One trend seems to be that the funded claims are quite high in value. The largest claim is upwards of $700 million US. In the vast majority of cases, funded parties are acting as claimants. And in the one case where the claimant isn't being funded, the respondent was funded at a later stage in the proceedings when it launched a significant counterclaim. Disclosure of third-party funding was made by claimants mostly in the notices of arbitration. So funding was secured before the arbitrations commenced. And the cases are mainly seated in Hong Kong, but there's also a few in England and in Russia. Now, so the juicy part, we thought we'd share with you perhaps just to give you a glimpse of some selected case studies, cases that we're funding or have funded in the past, very recent past. We are funding one of Hong Kong's first funded international arbitrations in Hong Kong. It's an IP dispute and it's administered by the HKIAC under their administered rules. And it involves a Chinese party. Our client is a Canadian corporate, and it is very attracted to this funding option because it allows the client to manage its risk, and primarily China risk. One thing I should say here that we are certainly, China is not an easy jurisdiction to fight in or to enforce in, but we certainly are able to do that quite effectively. The next one down is a portfolio of international commercial arbitrations on behalf of liquidators of a petrochemical supply company. This is again under the HKIAC rules and also the UNCITRAL arbitration rules. Also involves Chinese parties. We used one large case in terms of the claim value in the portfolio as a collateral to fund the lower value cases. And this benefits creditors who are major international gas suppliers. And we predict that there will be a multi-jurisdictional enforcement actions required. The next one down is a regional Chinese airline. And this is CTAC arbitration proceedings, international arbitration proceedings, seated in Beijing. Our client is a Chinese SOE, and we managed to devise a commercial deal that would give our client the flexibility to settle the case at their discretion if they were required to withdraw the claim from higher up, for example. investor-state arbitration as well. We have a relatively rare example of a bilateral investment treaty claim involving an Asian state, especially given the risk profile. This case is significant because there is a real access to justice angle. Our client is an individual with what we hope to be a very meritorious claim against the state, and needed funds simply to bring his claim. And lastly, we are also funding an Asian steel manufacturer in an international arbitration seated in Switzerland. The client's a major Asian multinational. And the reason why it was interested in funding was to manage its risk, primarily enforcement risk, because the respondent is based in, shall we say, a developing nation where things are actually quite hot at the moment. And it also helps them to manage their business unit's legal budget because it's clearly an issue for them. They did not want to spend a single cent on the arbitration. Well, that's it for me. So let me pass on to the role of funders.
Thanks very much, Cheng-Yee. I'm going to be brief on this section. The first slide really just sets out some background in terms of the benefits that clients are looking for when they're using funding. Cheng-Yee, if you don't mind just scrolling to the next one. Thank you. And really, I think in a nutshell, the essence of what clients are looking for if they're pursuing funding is to either pursue their legal rights without or with a significant reduction, either to their cost and or their risk of doing so. And they can do that through those number of reasons that are set up there on the slide. They can either unlock the intangible assets, the value of those, to bring cash onto the balance sheet, either in terms of working capital or just having the expenses of those proceedings covered, or in terms of risk management, having a third-party objective review of the case that can be very helpful to present to shareholders or internal stakeholders about the sort of, you know, the value of the claim from an intellectual perspective. And also in terms of the adverse cost risk, passing that on, that also is another advantage of using funding. And moving on to the next slide, again, just to highlight the types of companies that are using finance. So those that, you know, you might encounter who are, you know, using this as a remedy or something that they can have recourse to if they're pursuing a dispute. And really, it's just to show that they're companies of all natures, and they have different benefits from the list on the previous slide in terms of why they might be choosing to have, you know, to use funding in their disputes. Multinationals and conglomerates, for example, you might not think so, but there might be budgetary constraints between their different sort of siloed entities or divisions within their group. It can often be risk management, particularly on an enforcement level, depending on the jurisdictions that they're looking at. Listed entities, in particular SOEs, the balance sheet benefits are often very apparent to them, and that can be a very enticing reason to use funding. Those companies who are looking to list, in particular, the benefit of having a third party assess the merits of a case can be very important, as well as the cash flow benefits in terms of sort of shoring up the financial position of the company before it moves into that very important IPO stage. And then all the way down through SMEs, private equity firms are increasingly considering funding in terms of how they bring that into their business model. It's used across industries. Financial services is an industry where we're seeing increasing interest. Particularly, you know, you might be looking at subrogated claims for insurers, so they want to bring in a funder to offset their risk. The recovery of non-performing loans, monetization of awards, etc., are all very important for different industries in different circumstances. But moving really to the practicalities of how the funder's role works in a case where we're involved. If we move on to the next slide. It's really quite a simple process, at least we think so. There's really three main steps. And the first one is that we would have a very high level conversation to understand the basics of the dispute on a no-names basis. We would put in place a non-disclosure agreement to then protect the communications that we have with a potential client. And then we do an initial assessment of the case. And in terms of our assessments, when it's at this initial stage and also later when we do our full due diligence, there's really three important criteria that we're looking for in any case. The first one is based on the legal merits of a claim. People often ask if there's a particular percentage of likelihood of success that we're looking for. that's impossible to take a subjective view of. So what we're effectively looking for is good prospects. So we want to understand the basis of our clients' claims, what defences there might be against it, and basically a reasonable assessment of the client prevailing ultimately. So that's what we're looking for on the merit side of things. We also need to look at economic viability, and that has a number of different aspects to it. So first of all, we're looking at the amount of funding that might be required. As Cheng-Yee mentioned already, we can fully fund a case, so that means we'll meet all costs and disbursements that might be involved, but we can also partially fund, and that really depends on what the client would like. So they let us know how much funding that they're looking for, and then the second element of economic viability looks at how that compares to the ultimate claim value. And that's not the highest possible value that we might be able to squeeze out of the best favourable judgment we can possibly get. It's really taking an objective view of what the realistic claim value is, and also on the third part of this economic viability triangle is how much can actually be recovered, because it's all very well and good to have a strong case on the merits that has a high claim value, but if we think, or if our specialist team thinks that only a certain portion of that might be recovered at the end of the day, then ultimately that's what we have to consider as the realistic claim value. So that's the second thing that we look at, and also taking into account the recoverability as well, which we look at the early stage. So effectively, we do a very high level assessment of those three things. And if we like the case, we'll offer indicative terms of our pricing, because if there's no agreement on the commercial terms, then there's no point in us doing a full due diligence. So once we have a term sheet signed, we then move into the further due diligence phase, which we then conduct again on the same criteria. And then if we like the case, we'll present it to the investment committee for their approval, and we would then move to put a funding agreement in place. Ultimately, how long that takes depends on how much information is available to us on each of those three criteria. So then if we are looking at a case that we have funded and we've got an LFA in place, then, how does the relationship work? And if we can look to the next slide, essentially, we then move into a scenario where you have a tripartite relationship, where otherwise it would not be, it would just be, a relationship between the clients and the lawyers. But effectively, the relationship between the client and the lawyer doesn't change. It's the client who remains the decision maker. They are the ones who provide the instructions to the lawyers, and we simply come in as a entity that provides the finance. We also do provide the experience and expertise, but that is on a advisory basis. We are not directing the pursuit of the claim or providing instructions to the lawyers. So this is just a little bit more clear on the next slide if we have a look at the actual contractual relationships involved. So up the top, you can see that there is the LFA, or the funding agreement, effectively is this top arrow that exists between us as the funder and the claimants. And that effectively outlines the obligations that we have in terms of the provision of capital, what the budget is, in what circumstances, and what we will recover on success. And that's clearly specified in the funding agreement, so all parties know at all times what our return is going to be. And then also it means that we assume the risk, the binary risk of the outcome in the dispute. So if we've agreed to it, then, as Cheng-Yee's already mentioned, coverage of adverse costs. And then in the middle there, you can see the arrow that is the claimant's retention of the legal professional. So as you would have in any other case, there's a retainer agreement. The claimants are still the ones to initiate the proceedings. They instruct their legal team. And very importantly, I think people are always anxious to know that they retain the right to agree a settlement. By all means, the funding agreement does cover how any divergence of views might be resolved in relation to a proposed settlement or the making of an offer. But again, there's a clear sort of circuit breaker mechanism in the funding agreement that deals with that. And from a practical perspective, it doesn't really arise particularly frequently because of our due diligence process. We've tried to come to a point where the clients and our interests are very much aligned. So there usually is no disagreement about settlement. So that's a very quick look at how the funding process works in practice. And now I'll pass over to Marjolein, who's going to get to the meat and potatoes in terms of how we actually bring money in the door once we have a successful award.
Thank you very much, Ruth. Achieving a favorable board or judgment feels like a success until it isn't honored. Imagine having arbitrated for several years, having spent over $2 million in arbitral fees and legal fees, and finally winning a $12 million award and then not be able to collect payment. And this is exactly what happened to our UK client in a US arbitration against a Nigerian respondent. My company and I were not involved in the arbitration and only got this case when the award was rendered and we were asked to assist with the enforcement. And the first thing we did was ask somebody on the ground to assist with the service of court documents to the respondent's headquarters in Lagos. And that local contact went there and actually took a picture of the headquarters, which turned out to be an empty plot. What came to light was that the respondent was gone, used the time during the arbitration to restructure the whole company and dissipate all assets. And unfortunately, that arbitral award turned out to be just a very expensive piece of paper. Well, when debtors hide assets or prolong proceedings, we actually are experienced in dealing with that, and we can help and recover monies owed to our judgment and award debtors. And if there's one thing I would like you from our end to take away from this session is that although the strength of the merits of a matter is very, very important, collectability is key in the end. And on this slide are some common pitfalls that we see when clients come to us or lawyers for their clients with cases. And one of them is waiting with the enforcement actions until the arbitral or setting aside or annulment proceedings at the seat of the arbitration are concluded, waiting for the award debtor to pay and trusting promises to do so in the near future, pursuing recognition and enforcement in only one jurisdiction, as opposed to a more comprehensive multi-jurisdictional enforcement strategy. I will talk about that a little bit later, and ignorance on time-bar issues and different national rules that apply. Next slide, please. I'm going to be very quick about it because much of this was already discussed before by Cheng-Yee on the services that we offer. The same services that we offer for merits funding actually also applies to the enforcement services. Other than that, this is really aimed at helping clients monetize claims, judgments, and awards. But as you can see, if it's expected a respondent will evade payment, then we can provide funding and assistance in the pre-award phase as well, pre-judgment, so during the merits funding, but also after. And like the merits funding, as discussed before, also we do not charge a recovery fee. Enforcement funding is non-recourse, and we only recover our costs and a payment from successful recoveries for our clients. Well, also there goes again, we can purchase claims or awards for enforcement. And there's also a hybrid model where we actually provide an upfront payment to the client while the enforcement or recognition proceedings are ongoing. And lastly, I would like to mention DARB, and that is actually the Distressed Asset Recovery Program from the World Bank tech branch that's called the IFC. We are the only dispute financier that was chosen by the World Bank to actually assist in their program. And that means that we have been tested. We have been subjected to an extensive due diligence, and now we're actually working on that with the IFC team in the MENA region, and our DARB team is based in Dubai. Next slide, please. I think one back. Yes, there we go. Thank you. So how do we deliver results for our clients? Well, we always try to get the highest possible amount in the shortest possible time. And as Ruth said, that doesn't always mean that we go for the 100% for the long run. Sometimes it may be, we just look what is possible and what is the highest possible amount that we can get out on behalf of our clients. But we always try to get most, obviously, and to do that, we use various legal instruments. And as said before, we try to use a multifaceted strategy among jurisdictions to create leverage. And first and foremost, asset enforcement is very, very relevant here. There should be made a distinction between assets that have a high value, but a low impact. For example, passive non-strategic shareholdings. On the other end of the spectrum, we have the low value assets that have a very high impact. An example of that could be grounding an airplane. I mean, an airplane that can, of course, very expensive for the client, but if you're talking about a $100 million award, then the value of that plane or actually grounding it is very low compared to the actual value of the award, but it can be very disruptive to a counterparty, and that will definitely get the attention of your counterparty. So as I said, high attention value is usually more important than a high nominal value of an asset. I would like to note there, though, that attention is not the same as publicity. Publicity can usually work counterproductive, because as soon as certain discussions start being included in the media, that sometimes really forces your counterparty to say statements like, we're never going to pay, this is all wrong, they should go away. And then, of course, settlement will be later on quite difficult to achieve. There's also non-asset or financial leverage, for example, impact on trade relations or financial ratings. Other legal leverage, for example, get involved in other arbitrations where your counterparty or respondent is involved in. Another tool could be force your debtor to post security during arbitral proceedings or during enforcement proceedings. And that can be based on public or non-public default information. Just say that your counterparty cannot be trusted, and even if they intend to force recognition and enforcement proceedings, force them to actually put up a deposit that may actually also get them to the settlement table. And last, there is diplomacy. That is usually not very effective as a standalone basis, but usually it's very relevant to bridge the last gap, especially when you're dealing with states or state-owned entities as a counterparty. So what do? We try to go across jurisdictions and enforce across jurisdictions. And for that, it is important to sequence the enforcement actions in jurisdictions based on the arbitration friendliness for recognition. So, of course, you always want to start in countries that are a party to the New York Convention, that are open to recognition, and we think where the arguments or the possibilities to not allow recognition are very limited. Other relevant factors for the enforcement strategy are time limitation considerations, and also whether the recognition and enforcement proceedings will be ex parte or inter partes. When you want to attach an asset, you want to ensure that your counterparty will only be put on notice after the fact, and not while they can still clear out the bank account or let the plane leave the airport. But it's also relevant to try and time the asset seizures as much as you can at the same time. Also relevant is, and that's there we come to the value of our experience, is to make sure that you're also aware of the regional customs and cultures. Especially again, when dealing with states and state-owned entities, it's good to work together with a party that has experience with successfully negotiating with heads of state and government officials. So this is all in the recognition and enforcement state, but of course, this is all also relevant prior or during arbitral proceedings. Ask yourself during or prior to arbitral proceedings, is it possible, will it be possible that, or even likely, that counterparty or respondent is expected to evade payment of the arbitral award? And this can be due to the fact where the respondent is located, often in jurisdictions where enforcement is challenging, or because who or what that respondent is, a state, state-owned entity, or a very large corporation in a challenging jurisdiction, where you know that they will be able to influence the courts there. And if evasion of payment is expected, then we will work very closely with our own in-house asset trace team to identify where the respondent assets are located. And we will not just be focusing on hard assets like real estate and airplanes, but also trade flows or monetary flows. And when these assets are identified, we would then monitor these assets throughout the arbitration. And if it appears that anything changed in a asset position, then it might be necessary to actually already take conservatory measures or an injunction to provide to prevent the transfer of assets. Next slide, please. I'm very aware of the time, and I also can tell you many more stories on how we go about it. But I think what I really would like to underline here is that asset tracing and enforcement is no place for beginners. Unwilling debtors can be very adept at hiding assets throughout the world. Tracing assets and recovering debtors around the world also there requires a global team with the expertise there. And I can proudly say that I'm sorry, I pressed something. As you could see on the map that Ruth showed before, we are located all over the world, but we also have many colleagues with various backgrounds, common law trained, civil law trained. We speak a lot of languages among us, and that's also very helpful, not just to communicate with your clients and the lawyers, but also when you actually want to negotiate and try to come to a settlement. So I think that is, well, the feedback that we get from our clients, that they really appreciate that we actually can give that expertise as well. So the next slides, there are some examples of case studies of enforcement and recovery cases that we have been doing. As Cheng-Yee also said before, we do not shy away from cases against parties that are based in the PRC. And even though we try to focus on assets outside of the PRC, we also are engaged and have been engaged in recognition and enforcement proceedings there. So that first case here, that it was actually for the enforcement of an ICC award in favor of a European-based client against a Chinese corporate. And we funded and developed the execution of a global enforcement strategy, including in the PRC. And at the moment, the award has been recognized in several jurisdictions. And we also managed to attach assets, and that really, well, puts on the pressure. The next one is also a case against actually a Chinese parastatal. And there we had a Singapore client that had a dispute with a state-owned entity in the PRC. And that award was from 2016. And of course, well, of course, but otherwise it doesn't come to us. When it doesn't land on my desk, of course, the counterparty evaded payment, didn't want to pay. And we funded and developed the execution of a global enforcement strategy with a particular focus on the PRC. And that case was settled after initiation of enforcement proceedings in PRC with the actual involvement of the PRC courts. I think I will discuss one more, because I think we should also go to your questions, because we're very interested to see what you want to know from us. But the last one I just want to underline is a case that that shows more on how we look at a case, and that we do not just focus on the jurisdictions where the parties are located, but actually all a little bit more out of the box. That case is actually where we asked for a discovery order from a US federal court, and it was for discovery against a case for enforcement of an award against an Indonesian debtor. And we actually wanted, we got the assistance of the US court to get information on that Indonesian party, and that actually assisted us with discovering bank accounts and other trade flows. And by doing that, we could actually also successfully attach assets there. I would like to stop here. If people are interested in more case studies or more stories, please reach out. We're happy to take the discussion further, but I would like to see if there's any questions that you have for us. And thank you for your your focus here. Thanks.
So I think we haven't had any questions come in through the question and answer function yet. Had anyone noted down anything that was of particular interest to them, or a question that they had on any of the different sections that we've covered this evening? Well, if not, perhaps we can do everyone a service and wrap up 5 minutes earlier and say go and enjoy your evenings, and thank you very much for joining us. I don't know if there's any last minute, races to ask us anything, but if there's not, then please, the slides are going to be put up, I think, on the website for your information. The case studies will not be included because that's got our confidential, elements of those are confidential. So if you want to learn more about any of those aspects, our arbitration work in Hong Kong, for example, or the enforcement cases that Marjolein was sharing, or anything else that we've covered tonight, please don't hesitate to be in touch with us. Our contact details are on the slides, or you can find them on the OmniBridgeway website. And there's a number of interesting things if you're interested in learning more on our website, or likewise, just reach out. We're always welcome a conversation if you'd like to know more from us.
Yeah, if I may add to that, Ruth, very, very briefly, as you said, we are not lawyers. We are always happy to look at cases. We're always, for me particularly, I'm very happy to look at awards that you may have lying around that you think they are not enforceable. I don't know, I should talk to a lawyer, but it's going to cost me or my client a lot of money. Also potential funding, we're always happy to brainstorm with you, also on merits funding cases, explore possibilities. You have our email addresses. I think they're also included in the slides that you will get. And yeah, we're just looking forward to hearing from you, and it would be very nice to brainstorm together.
Yeah, we definitely don't charge for our due diligence.
We do not.
So when in doubt, reach out. There you go.
When in doubt, reach out.
Thanks very much, everybody.
Thank you, everybody.
Thank you.
Good night.
Take care. Bye-bye.